Tonight's daily workshop is personal and estate planning. The speaker tonight is Emily Clough. Emily is with a lawyer with the Alexander Holbrook. Also, we have Barbara Lindsay. Barbara is a senior manager, advocacy and public policy at the Alzheimer Society of BC.
Hi everyone, this is Emily speaking, and Barbara is here with me. Sorry for the delay in getting started. Because we've been a bit delayed in getting started, we're going to skip right through the first several slides and go into the legal planning aspect, which I can talk about in slide 8. I'm moving to slide 12, and it should be titled Enduring Power of Attorney. So what we wanted to talk about tonight was the planning documents that should be considered for anybody who is dealing with Alzheimer's or can be considered by anyone who's assisting somebody who may have Alzheimer's. It's important to have your planning done early because it's possible that you might lose the ability to do that planning later on. It can help your family in planning. It can help your caregivers and your healthcare providers to know what your plan is. Unfortunately, it's not a simple thing to plan. It does take thought, and there are a variety of tools that we use to do planning. So we're going to go through those tools tonight. The first one we'll talk about is an enduring power of attorney. A power of attorney is a legal document. It's usually best if you can do it through a lawyer or a notary. It appoints a person to act on your behalf for all of your financial and legal matters. So it's a very powerful document. It means that you could appoint someone else. It could be your spouse, it could be your child, it could be a friend, it could be a company, a trust company, to deal with all of your legal and financial matters. That would be your bank account, your property, if you have a house, if you have a condo, your vehicles, or your investments. It's a very powerful tool and allows anybody who you appoint to affect those matters on your behalf. So somebody could sell your house or remove money from your bank account, pay your bills using a power of attorney. What a power of attorney does not cover is health or personal care. So a different document is made in order to allow somebody to appoint who they would like to make health or personal care decisions on their own. I'm going to flip to the next slide, which is slide 13. This is titled a representation agreement. A representation, again, is a legal document. It's a document that you can make if you'd like to appoint somebody to make your health care decisions for you. Your wishes, if you would appoint somebody as your representative, you can tell that person what your wishes are. If you have a wish to reside at your home for a certain length of time, you can tell that to your representative. If you have a wish to receive a certain type of care or not receive another type of care, you can tell that to your representative. In making your health or personal care decisions for you, the representative should be guided by those wishes. So this document may help in making things easier for your friends or your family because it would set out who is that person who is supposed to make these health care decisions. The representative will act on your behalf in making those health care or personal care decisions. The representative will make decisions if you are incapable of doing so yourself, if you're unable to express your wishes, or if you need somebody to assist you in expressing your wishes. The representative would be able to do that. So it's the power of attorney, our last slide, which would appoint somebody to affect your financial affairs or your legal affairs. And it's a representation agreement that would appoint a representative to make decisions on your behalf regarding your health care and personal care decisions. I flipped the slide to slide 14. and this is about an advanced directive. An advanced directive is a new document that took legal effect in British Columbia in September 2011. This document, as with the power of attorney and the representation agreement, it must be made when you are capable. It's not a black and white decision as to when you are capable, and each of these different tools that we'll describe tonight has a slightly different test for when you are capable of making them. This is part of why we recommend people to plan far in advance, because it's not always clear. It's not a flick of a light switch on and off when you are capable and when you are incapable. It's more of a gray area. It's hard to tell. But if you do know that you have capacity, it's a good time to make your plans in advance so that there is no doubt. Much of the work that I do in my practice involves when things have gone wrong, when a document is made, when somebody may be incapable and there may be fights about whether that document is valid. And that can be a very tragic situation, which is why we really strongly suggest that people plan as early as they can. So looking back to the slide, an advanced directive, it is a document that allows you to set out in writing your instructions for consent. If you have a specific type of health care that you do not want to receive or that you do want to receive, you can set that out in your advanced directive. We do find that these advanced directives are primarily used for end-of-life decisions. So this document may set something out like, if I am in a coma and I'm unable to respond, I do not want to receive this type of treatment. People may also use an advanced directive if they know that they do not want certain treatment like a blood transfusion, and they would like to ensure that that wish of theirs to not receive a blood transfusion is known no matter if they're capable or incapable of expressing it. So the advanced directive is a helpful document because it can set out for your family and more importantly for your healthcare providers what it is that you know that you want or you don't want, such that if there is a time in the future that you're not able to speak for yourself, then this document could speak for you. Like the power of attorney and the representation agreement, an advanced directive needs to be properly signed in order for it to be effective. The new law says that you have to have 2 witnesses to it. You only need 1 witness if it's a lawyer or a notary. An advanced directive is part of the set of tools that any lawyer or notary could assist you with. We do, I of course being a lawyer, do refer people to try and seek legal advice regarding these documents to help get some assurance that they're done properly, that they will be valid, and that they will express your wishes. That's the ultimate goal that we're trying to achieve with these tools, is that your wishes are set out in the way that you want them to be, so that your family, your friends, your healthcare providers know what your wishes are, and those wishes are known despite any future incapacity that you may face. I'm going to move on to the next slide, which is called Comity Ship. I know I've been going through quite a few things here, and it's hard when we're not able to ask questions during the presentation, but I hope that this is all making sense for you all. A court-ordered declaration that somebody, they would be called the patient, that's just the term the court uses, is no longer capable of managing themselves or their affairs. So what that means is that the court could say that someone is no longer capable of managing their finances, they're no longer capable of making legal decisions, It also might extend that that person is not able to make their personal decisions. So decisions like, where do I live? Do I live at home or do I live in a care facility? What do I eat? What do I do during the day? There may come a time that a person is not capable of making those types of decisions. So what a comity ship does is somebody would need to apply to a court to say, please give me the power of being somebody else's comity. This person is not capable of making decisions for themselves, and I would like to be able to have the power to do that on their behalf. To have a comity ship, you do have to go to court. It requires an order of the court to have force. You have to bring to the court, or your lawyer would, if you hire a lawyer on your behalf, would have to bring to the court 2 affidavits of medical doctors in British Columbia. And those doctors would have to say that this person is no longer capable of managing themselves or their affairs, and set out the reason why and why that doctor knows it. We have an agency in British Columbia called the Public Guardian and Trustee. Their mandate is to look after minors, so children, or adults who are not capable of managing themselves or who may be vulnerable. Whenever you do a comity ship, you have to advise the Public Guardian and Trustee that you're applying to be a comity. So that means that the Public Guardian and Trustee will look over the application and will consider whether they need to be involved. They will look to see that the person who may be incapable is being protected, that their assets are being protected, and that they're not being taken advantage of. After the application is made, the court will make a declaration that a person is incapable, if that's what the evidence shows, and they will appoint the person to act as that person's comity. If you have a power of attorney or a representation agreement that appoints the person who would look after you, then you may not need a comity ship. An enduring power of attorney and a representation agreement survive any incapacity. So if you've made an enduring power of attorney or a representation agreement at a time when you're capable and they're validly made, and then you subsequently become unable to make decisions for yourself, then your attorney or your representative may be able to make decisions on your own, and a comity ship may not be required. There are times when a comity ship can't be avoided. For example, if someone is not able to manage their financial affairs and they're making not good decisions about their finances, perhaps there's a concern that they're vulnerable to somebody who's manipulating them, then you may want an order in order that that person can no longer have access to their bank accounts to protect that person. I move to the next slide, which is called healthcare decisions. If a person is unable to give consent themselves, the healthcare provider still needs to seek out consent. For a healthcare provider to do any services, they need to have consent of the patient. So if that patient is unable to give consent for themselves, the healthcare provider is going to look to see who can give that consent. And as we've gone over, a representation agreement is likely that document that the healthcare provider would want to see. They would look to the representation agreement, and if it appoints someone, then they would ask that person for consent to that treatment. This is why it's important to have a representation agreement handy, or a power of attorney, and to let your attorney or your representative know that you've made this agreement and that you've appointed them, so that if something happens to you and you're going off to the hospital and you're unable to speak for yourself, then your representative or attorney knows, oh, I better go get this document and bring it with me to the hospital so that I can make those decisions and the health authority can look to me to be that person to make those decisions. If there is not a representation agreement or a power of attorney in place, then the healthcare facility will look towards a default scheme that's been set out in a piece of legislation. So if there's no other document, then the person authorized to give consent is first of all a spouse. And if there's no spouse who's able or willing to provide consent, then they'll look to any children, and then they'd look to any siblings, and the list goes down from there. So the things that we've talked about so far are a power of attorney, a representation agreement, and an advance directive. Those documents are all things that speak during your lifetime. They stop speaking at the moment that you die. The power of attorney, the representation agreement, in the advance directive are things that will take effect during your life. But there's one document that will take effect after your death, and that would be your will. So that's our next slide, slide 17. A will is a technical document, and there are some specific rules and laws that have to be met in order for your will to be valid. It must be properly signed, and that means that it must have two witnesses. So the person who's making the will, we would call them the testator. The testator signs the will, and two witnesses sign it. And those witnesses can't be a spouse of a beneficiary or a beneficiary. Your will should appoint an executor. An executor is the person who will step into the deceased person's shoes. The executor will have authority to deal with the deceased person's bank account or real estate or debts or gather in other assets, whatever they may be. So you want to consider when you're dealing with your will who you would trust to do your role after you have died and manage your affairs and distribute your property as to how you would like it to be distributed. And that's really what a will does. A will sets out what will happen to your assets at your death. You can choose who your property will go to. As with the other documents, a power of attorney, a representation agreement, and an advance directive, you have to have the required amount of mental capacity in order to make a will. We do often see challenges to this, so it's another thing that is important to plan ahead for and plan before there may be any concern for incapacity. So the mental capacity required for a will is that you need to know who your beneficiaries are. So you need to know who your family members are. You need to know what your assets are. You need to know what it is that you are giving away under your will. You don't necessarily have to know every single nickel and every single dime, but you do need to know approximately what you have. So you may have a house and it may be worth $500,000. You may have a bank account that has $25,000, and you may have some investments of $150,000. You need to know those basics of what your assets are. You need to know that your will takes effect upon your death, and you need to not be under any delusions about your property or about your beneficiaries. And of course, you need to understand the provisions of your will. If you go to see any lawyer or notary regarding preparing your will, they should take you through sort of a test, a bit of a checklist to make sure that you know all of these things before they would allow you to sign your will. One thing to note in British Columbia is that we have a law called the Wills Variation Act. And what that law says is that if you have not made adequate provision for your spouse or for your children, then a court may vary your will. A court may change the distribution that you have set out to be something different. So you want to be cautious when making your will to take into account your spouse and your children and make sure that you're making an adequate provision for them. You can consider writing out in a separate document or in your will why you have made the distribution that you have. For example, sometimes a person has already given one of their children a significant asset. Perhaps someone has already bought a house for one of their children, but never bought anything significant for the other child. Well, that person may wish to give the child who did not receive the house more under his or her will. In that case, that should be documented so that everyone knows why that distribution was made. If it's not clear or if it's not documented, then there may be a challenge to the will under the Wills Variation Act. And under that act, the court can decide how your estate should be distributed. The next slide that we have is slide 19, and it says when there is no will. That's what would be called an intestacy. And what that word means is simply that you have died and you did not have a will. In that case, your estate will be distributed according to a scheme that has been set out by the government in our laws. So if you die without a will, so you're intestate, and you have a spouse, but you don't have any children, then everything will go to your spouse. If you die without a will and you have a spouse and you have 2 children, then your spouse will get $65,000. They will be able to live in what was their home, your matrimonial home or your normal home, for the rest of their lives. And then the rest of the estate would be divided 1/3 to your spouse and 2/3 amongst your 2 children. And the scheme goes on from there, and it deals with situations when there is no spouse and no children, and it goes to your more distant relatives. We usually recommend that people do draft a will. You may be satisfied at the moment with how the government has set out what will happen to your estate, but there's no guarantees that that scheme won't change in the future. The government can change that scheme by legislation as they decide. If there is an intestacy, you would have the person who will be in charge of your estate would have to apply for administration of your estate, and that has to be done by a court application. It can be a little bit more cumbersome than what an executor would have to do if you had a will that appointed an executor. An executor would apply for what is called probate of the will, if that was necessary. Probate is where the court says that the last will that has been presented to them is indeed the last will and puts their stamp on it, and that gives the executor the authority to go to the banks or to the land title office to deal with the deceased's property and assets. The last slide that we are going to look at, in my section anyways, is called joint assets. It's important to know what forms part of your estate that would flow through your will. So this is particularly important for planning for what happens after you die. If you hold an asset in joint tenancy with somebody else, it's very typical that people will, if they own their own home and they have a spouse, that they will hold their house in joint tenancy with their spouse. Then when the first of the 2 of them dies, the survivor will automatically receive 100% of the asset. it rolls over automatically upon death. So we set out in our slide that that's a joint asset will directly transfer to the joint owner. So you can hold property like real estate in joint tenancy, and you can hold other things in joint tenancy such as your bank accounts. So you may have your spouse as a joint tenant on your bank account. And if you died, then your spouse would automatically get the entire bank account. And the effect of that is that that bank account, which was held in joint tenancy, doesn't form part of your estate. That means that it wouldn't be distributed under your will. But if you hold every one of your assets in joint tenancy with your spouse, then everything would go to your spouse. Your children would receive nothing because there's nothing in your estate. There are pros and cons to holding assets in joint with somebody else. One of the pros of having a jointly held asset is that the asset will likely not be subject to probate fees. So when somebody has a will that gives away their property, so everything that's in their estate, the executor would disclose all of those assets to the government in the probate process and then pay fees on the value of those assets. The fees right now are about 1.4% of the gross value of the estate. So if an asset is held jointly, for example, a house is held jointly, that would automatically transfer on death to the survivor. It wouldn't fall into the estate, and therefore it wouldn't be subject to probate fees. Joint assets aren't perfect, especially in this day and age. They can be challenged. Somebody could challenge that a joint asset is in fact held for the estate. For example, at the moment, our law presumes that if a parent and a child are joint tenants on a bank account, the law will presume that the parent intended for the child to take that bank account after their parent died and then give it back to the estate to be distributed under the terms of the will. So it wouldn't be subject to probate fees, which is a benefit, but it can be complicated because the law would presume that that child is supposed to give the bank account back to the estate. It's tricky because that may or may not have been the parent's intention. The parent may have intended for the account to go to the child and not to form part of the estate, or the parent may have intended that the asset go back into the estate. So it's important to document what the intention is and to seek legal advice and to seek advice from your bank about what it is that you really intend when you have a jointly held asset. I think that's the end of what my part of this presentation was. We have two other slides, 21 and 22, where we give some resources that you might wish to consult if you have questions regarding these types of plans or would like some further information. And we close with a word of advice of an ounce of planning is worth a pound of cure.